Hi, and welcome everyone to this episode of Watch Other Students Do Some Work, or WOSDOSW, volume, I think, 17, 19, whichever one it is. It's 17. And today we have Andrea Dodds and her son, Alexander York, or Alex York. And they're going to tell us about the legal side of business, how to protect your practice. Andrea is not just an excellent hypnotherapist, but she's also, let me read this. She's also a risk management and legal compliance consultant. So she knows everything about the little paragraphs and letters and all the legal stuff. And even more about the legal stuff knows her son Alex, who has a first-class honors degree in law. And they're both co-founders of Nature's Way Lifestyle. I'm going to mess up everything. So I'm going to shut up and I'm going to let Andrea and Alex take over. Go ahead and introduce yourselves first, and then just go ahead and do your presentation for us. Thank you.
Oh, thanks, Astrid. Everybody, thanks for coming. The reason why we're doing this is because it's become very obvious to me in a short space of time that there's a lot of therapists, hypnotherapists, coaches, NLP practitioners, and the like that are qualifying, getting certified, and they are giving excellent service by way of therapy, but they're neglecting the fact that they are also a business owner. And because of that, they are running into all sorts of problems. So we will touch upon some of those in the next few minutes. We've got slides that are there for basically aid memoirs for us, but equally there's notes that you can take. And because it's being recorded, you can obviously replay it back at any point in time. So hopefully you've got that on a full screen.
Perfect.
Yeah.
Brilliant. So what we're going to be doing is we're going to be looking at doing business on your terms. And that's going to be the crucial part of this entire presentation. What it'll do is it'll give you legal peace of mind for coaches, hypnotherapists, and NLP practitioners on the rise, and make that, therapists generally as well, and counsellors. And as Astrid said, both myself and Alex will present in. Let's see where we go. So what we will be covering is, Alex and I will introduce ourselves properly in a second. We're going to look at 3 common headaches. And these are comments and messages I get quite a lot of the time. They'll also give you some screenshots from real life scenarios so that you can actually see some of the messages that I've had. Another side will be, you're not just a therapist, you are also a business owner. And that's essentially what we're going to be addressing today. Other key bits we're going to be looking at are terms and conditions of business. We're going to touch on data protection and GDPR. And then we're going to be looking at 5 essential documents that your business needs. Now, what I will do is just throw the disclaimer in there that this webinar is for general information only, and it should not be considered legal advice, because obviously everybody's got a different business and that would need looking at on a case-by-case basis. So, I'm Andrea. As Astrid has said, I'm a co-founder of Nature's Way Lifestyle with Alex. I'm also a risk management and legal compliance expert, specialising in health, safety and well-being. So what that entails is I, for over 25 years, have been auditing large companies across the UK for legal compliance. So I've been checking things like their terms and conditions of business. I've been checking things like GDPR compliance, management systems, which includes policies, procedures, and systems that are in place for what if something goes wrong. Now, part of that includes risk assessment and risk management. And basically what we've put together today is essentially a risk management tool to help you protect yourself and your business against these little headaches, shall we say, that could also become very costly expenses. So over to you, Alex.
Yeah, I'm Alex. Nice to meet everyone. I'm also co-founder of Nature's Way Lifestyle, sort of focusing on the nutrition side. And as Astrid mentioned, I've graduated with first-class honours in law and politics from University in London, and I've got aspirations to qualify as a commercial lawyer. So much of my modules at university were directed towards sort of acquiring the academic foundation of commercial and business law principles. So yeah, I'm very excited to sort of present the rest of it to you guys.
Thanks, Alex. Okay, so 3 common headaches that can be avoided. Let's launch straight into it. First one, refunds. The second one, cancellations and no-shows. And then the other thing, sickness and technical issues. Now, what I'd like you to do is I'd like you to put yourself in the position of a normal purchaser. Just everyday kind of situations where you're going to buy things. So let's say you've gone into a shop, you've bought an outfit, you've taken it home, you've tried it on, you find it doesn't fit. Can you get your money back? Can you be refunded? Now, obviously, the terms and conditions for refunds are going to be dependent on that particular store or that particular company. And one store and one chain may have differing refund policies. Some might say, yep, bring it back, you can have your cash back, no problem. Another might say, no, we don't do refunds, but we do credit notes. So the refunds part from a therapist perspective is going to be crucial because you ultimately decide what your refund policy is going to be and you decide how that looks. So it's important that you know what that is and that you communicate that in some way. Now, as far as cancellations and no-shows go, let's think about this from you as the business owner of that therapy practice. Your client fails to show or they cancel at the last minute. How is that going to be a problem for you? The chances are you've allocated that time for that person, and that failure to show is potentially a hit on your revenue and your income. And then there's something like sickness and technical issues. What's the state of play if you're sick or if you run into technical issues and you can't deliver that therapy session or that course or that workshop? These are sort of things that can be avoided, and I'll show you how. Because one of the main problems I ask is, I'll tell you what, let's deal with these ones first, because we'll come back to these in a second. So what we've got here, these are screenshots of messages that I've had asking for help. So I'll just read them through one at a time. So refund, ick. I've had a refund request for a retreat today. It says on the invoice, cancellation is non-refundable. I have emailed back with love, as kind as I can, and explaining there we have a no refund policy. Alex, do you want to do the next one?
Yeah, of course. So down to the blue. So I've been feeling very burnt and my confidence has plummeted. 4 months later, if she'd paid a third of what she owed me, she wrote an email saying that she was stopping her payments with Stripe and had asked her bank not to pay me. I'm furious. She's had over £797 worth of training for only £250. The icing on the cake is that she's also ripped off a course of mine and put it on her own website.
Another one there, which is the bottom of the second column. I'm currently getting roasted in a local moms group as a scam artist, and I just had to do the largest refund to a client in my life because they threatened to sue me. Please help me reframe this and stop feeling so effing hurt and sad.
Yeah, and another one, so this is referring to sort of cancellations of an event and sort of a breakdown of a partnership. So I've been working with this client for 3 years and I've always had a great relationship with them. Extremely surprised when I open an email to read that after speaking with the CEO, they need to cancel the event and will not be able to reschedule. They've also asked if they can be refunded.
Another one is I'm slowly building my client base in somatic trauma therapy, and I simply can't afford to let sessions go without payment. I'm obviously not going to fill that time, and being self-employed is precarious enough in Denmark anyway. I've written back and asked her why she's decided not to continue. We've only had 2 sessions, but my sense was that this will really help her. I'm working with people who've suffered trauma, and as such, there are bound to be, as with all of us, some bumps in the road of therapy. But I don't know how best to deal with situations like this. I can only think that the cancellation is because I charged, but she's also signed an agreement that says she'll give me 2 weeks' notice.
Yeah, and another one, it's a bit of a sting to have to look at refunding $2,500 with no explanation. And then other than refunding, I could certainly ask to chat with the CEO to find out if there's an issue and offer them something else for an amount they've paid, such as providing 10 to 20 of their prior workshop attendees with access to my digital recorded workshop. So this one, they're looking for alternatives to try and avoid a refund of that amount.
And then the last one, do you charge for late cancellations? Do I need to actually discuss this policy in the first session? Even though there's a signed agreement, I can't do anything about it. It's just such a shame that me holding boundaries means I lose a client in this way, because she's reacting by pushing me away when I hold the boundary. I know some of you will say, so she's not your ideal client, but as she's coming to me with stored survival stress and trauma, she actually is. Any thoughts? Has anybody had to deal with any of this so far?
Oh, yeah.
Bless.
Are you asking for general
Yeah,
questions
please
or
chime
comments?
in. Go for it.
Yeah, since the very beginning, I've had people pay up front with the cancellation policy that if they cancel in less than with 48 hours notice, that they may or may not get a refund. And I often give broad exceptions, of course, when there's emergencies or like the first time it happens, but I've never had an issue. The only issue I ever had was when somebody didn't recognize kind of the name of my business on their credit card statement and they filed a fraud report and I had to go in with them and like, that was from me, that was our session. And they're like, oh, I'm so sorry. But it was a big, pain to do that.
Yeah.
But and the reason why I started with having payment like that is I used to need to book a classroom in advance when people would sign up for classes. And I would tell people, look, I'm putting money out to rent this space. I need to have commitments beforehand. So I started thinking of it as like paying rent on my personal time or on my location. And to me, that just I've never had anybody kind of question that. So I wish others would just charge up front. And you could even tell people if you cancel, there's going to be a 2.9% fee for credit card processing, because that's when you lose out. Like if they cancel a big sum and you're like, oh my God, that just adds up. So I just want to encourage people to just charge up front. And, maybe you can share with us maybe the downside of doing that.
Yeah, absolutely will. Now let me share screen again and I'll bring it back to where we were. Bear with us a second. Because again, you've seen the noises there. Now, the first thing I do every time I get a message like that, the first thing I ask is, what do your terms and conditions say? Because Denise, you're absolutely right. Unless there's something in those terms and conditions, it's going to be very difficult to argue any case or even to be able to put any perspective in place, not just for yourself, but for the other person as well. And the beauty of terms and conditions is it stipulates how you do business. And this is all about business on your terms, if that makes sense. And the beauty of it is if you can put your terms and conditions on something like your website, even just your general terms and conditions, anybody that wants to do business with you, refer them to the terms and conditions on your website, because then they're broadcast and they're communicated clearly. The bottom line is that when they then click to book an appointment with you, they're effectively agreeing to those terms and conditions. And I'll share with you later on something else that I do as well, as part of the intake form when they sign up for like a discovery call, when they're ready to talk to me and get some help. So the key thing about today is just a reminder that you are not just a therapist or a coach or an NLP practitioner or a counsellor. You are a business owner. So being a service provider, either online or in person, is about setting clear boundaries with your clients, setting those standards and expectations. So terms and conditions of business are absolutely necessary to protect you and to make it clear what you will and will not tolerate from the other person. Now, without them, your business and yourself is inviting problems, stress and anxiety, and a potential loss in confidence and potentially reputational damage. Now, the unfortunate thing is, a lot of the people we're dealing with are potentially coming to us when they're not their best self. They're not in their right mind. They need help and direction and guidance. So this is where we have to step up and own that and be the authority in that relationship. Does that make sense? Okay, Alex, over to you for this one.
Yeah, perfect. So we've just outlined, like, say, the top 5 things that your T's and C's must include. There are definitely more that go into it, but copyright and intellectual property, jurisdiction, obviously payment and refund terms, if we've seen, liability, disclaimers and any exclusions, and dispute resolution clauses as well. So to go through them in slightly more detail, obviously with copyright and IP, everything you create in terms of your digital courses, resources, digital products can be safeguarded by your terms and conditions. As we've seen before in one of the examples, someone who not only had a refund request from her course also then discovered that her client was ripping her course off. So if clear terms and conditions sort of outlined that anything produced by herself and her business, was under the IP of her, then she'd be in a really strong legal position to then put a stop to that. So looking at jurisdiction, you in your terms and conditions get to choose which sort of law you sort of operate under, certainly linking to dispute resolution as well. It establishes it avoids you being dragged into an unfamiliar legal system, and ensures that disputes are also somewhat on your hands. Say, you're operating out of America, but you've got clients in the UK or you've got clients in the EU. English law is one of the world's largest dispute jurisdictions for businesses. So it's a really important term to have, just so if the dispute arises, you know where you'll be settling it. So that's the last 2 linked. Sort of payment and refund terms, obviously, as we've seen, it's absolutely blighted in this industry how many people sort of want refunds, certainly after the service has always been provided. Particularly thinking about the payment processes we use as well. Businesses get heavily judged on refunds. PayPal are very quick to put accounts on hold when there's a lot of money in there, and one transaction sort of has a query. So refunds requests, payment and refund terms really outline everything to the client when they sign up, what they can and cannot sort of get away with. And obviously in there'll be things like, after 14 days, there are no refunds, and things like that. So the terms are really up to you, and really help protect the business. Again, liability. This is about protecting yourself and not being held responsible for things beyond your control. As you say, a lot of the courses, the one-to-one sessions you provide, it takes a lot. The client has to show up and do their part as well. And if they don't get the sort of desired outcome, but they haven't done their part, then it really protects your liability in that sense too. So those 5, which are, dispute was linked to sort of jurisdiction, but if they're really clearly worded and understood, communicated properly, so they're accessible at checkout and things like that, then they're really strong to rely upon in any sort of situation. Yeah.
I have a question here.
Yeah, of course.
So if the client has to do their part, how do I have to communicate that to them? Let's say a weight loss session or weight loss hypnosis for weight loss, not one session, but several. Do I have to give them homework, explicitly explain to them what they have to do and what they can't do?
Yeah, it sort of depends definitely on the service. So if I'm thinking about sort of my nutrition service and the one-to-one, similar to yours, obviously perhaps the goal is weight loss. They're provided with everything I can do, but then if they don't go and follow the meal plan, then there's nothing more I can sort of do to enforce that. And you can sort of navigate that certainly in the T's and C's with things like disclaimers. So you can only do your part, but if you don't do yours, disclaimer, you're not going to get a refund for something you haven't committed to. Yeah,
Thank you.
that's okay.
Now the next slide, Alex.
Yeah, certainly can do.
Oh, it's my
Yeah.
okay. Data protection and GDPR. So GDPR is the General Data Protection Regulations. Now, they came in 2018. And as far as the UK is concerned, it's the Data Protection Act 2018 that transmitted the GDPR European regulations into UK law. So the UK GDPR, or Data Protection UK GDPR, is essentially how that translates now. Now, the whole purpose of data protection was to protect the personal information of data subjects. Now, essentially, a data subject is a person that is living, breathing, and has information, because information is big money to a lot of businesses. Now, there are strict rules applying to how and when that data is collected, processed, and stored by you, any staff that you have, and any third parties. And those third parties include things like contractors that you may use, even software companies. So let's say TidyCal or Acuity Scheduling, or even if you use a CRM or a website. So those service providers and software companies also handle that data, and they also might collect even more data than we do. Stripe was mentioned, PayPal was mentioned, and again, they're going to be processing data subjects, credit card information, potentially their addresses, their names, and any other bits of data that they need to. So again, part of the data protection regulations required that you needed to identify somebody within your business who is a point of contact for data control. And your business may need to be registered with the ICO, and that's the Information Commissioner's Office. They are the UK's regulatory body that deals with GDPR and data protection. And the best thing to do is, if you're not sure whether or not you need to be registered with them, is to go to the ico.gov.uk, I think it is, and you basically fill a form in online, and it will let you know whether or not you need to register. There are different levels of registration needed, and I think the basic one is something like £40 a year, and then there's another one which includes if you deal with sensitive information, and I think that's something like £60 a year. But if in doubt, go and check it out. Now, I mentioned third-party examples of data processing. So Acuity Scheduling is one of the products that we use when we take bookings for our clients. And as you can see, Acuity Scheduling is compliant with major data protection regulations, including the GDPR in the EU and the Health Insurance Portability and Accountability Act, or HIPAA, for healthcare providers in the United States. Now, TidyCal, up until very recently, were not GDPR compliant. Now, after a quick search earlier today, according to TidyCal's privacy policy and information available on platforms like AppSumo, yes, TidyCal claims to be GDPR compliant as of 2025, stating that they have features and processes in place to adhere to GDPR regulations regarding data handling and protection. Now, I do know from looking at this a couple of months ago to today, they do now have things like a privacy policy in place, which they didn't before. And it wasn't clear if you looked at TidyCal whether they were GDPR compliant or not. Whereas today, it looks like they could be. But I've not looked at their privacy policy. I've not looked at anything else to guarantee that for certain, or certainly not for my benefit to say that I'm happy with it. So whether your data suppliers or your software suppliers are, it's worth checking with them that they are GDPR compliant. So if you're using things like a CRM, a customer relationship management database, or an email service provider like who am I thinking? ActiveCampaign, ConvertKit, which is now Kit, MailChimp, that kind of stuff. It's always worth checking with each software company that you use to make sure they are GDPR compliant. Because if there is a data breach, then you are compromised potentially as a business, which means your data subjects and your clients' information is also potentially compromised. So there could be a claim made against you by one of your clients and that kind of thing. And obviously then if the bigger company's at risk, you need to know that from your perspective too. Now, the data subject under GDPR has rights, because this is one thing that the data protection regulations did bring in. They put rights on people. So you have the right to be informed. You've got the right of access. You've got right to rectification, right to erasure, right to restrict processing, to data portability, right to object, and rights related to automated decision-making, including profiling. So what that basically means is you've got the right to be informed that they're going to be collecting your data, who's taking it, and what they're taking. You've got right of access to the information that they hold on you. Alex, do you want to mute for a sec?
Yeah, sorry.
All right. So you've got right of access. So you've got a right to know what data they are holding on you. You've got a right to rectification. So once you've got that information, if you can see there's something wrong with it, you've got a right to have it rectified. You've also got the right to erasure, which means you can get the data removed and erased if you choose. There's a right to restrict processing. The data portability is the ability to move your data from one software company to another, should you choose to. So for instance, if you're using an email service provider like ActiveCampaign and you want to move to, say, ConvertKit or Kit, you've got that ability or the portability to take that database and move it from one to the other without any questions. You've also got the right to object to your data being processed or handled. And you've got rights related to automated decision making, including profiling. So anybody familiar with the UK, there used to be a TV series, Computer Says No. So when people would be applying for things like bank loans or credit cards, they would probably just get an automatic no, because it was an automated decision making based on the information you gave. So there are rights in relation to that. And the profiling part was, you could be any form of where it's being analysed or predict aspects concerning a person's performance at work, economic situation, health, personal preferences, interests, reliability, behaviour, location or movements. So some of this data could be quite intrusive. Now, when it comes to the right to be informed, I think, Alex, this is over to you.
Yeah, it is indeed. So the right to be informed of how their data is being held falls into a privacy notice, most commonly presented by companies as a privacy policy. Now, hypnotherapists, NLPs, coaches, NLP practitioners and coaches, you may be held to higher standards than many other fields because you're holding and processing information as part of your service, things like mental health details, medical history perhaps, and personal insights that are all classed as special category data. Now, under the UK and GDPR Data Protection Act, this type of data requires a higher level of care and compliance, and it's also so high level of care and compliance. So a well-drafted privacy policy not only keeps you compliant, but also shows your clients that their sensitive information is in safe hands. So having a really well-formed and bespoke privacy policy will just build that trust and demonstrate the professionalism. And of course, from a legal point of view, it mitigates the risk of receiving the higher maximum level of fines of disputes over misusing data. And as we've seen on the last slide, how different the language is even between acuity scheduling and TidyCal. Both are so-called GDPR compliant. TidyCal was well behind acuity, and even now the language is very different. It's how they use. So sort of a bit of due diligence on that part from yourselves to think, okay, who's really explicitly, gone for GDPR compliance, and what sort of processor can you trust? Yeah. Yeah, so sort of leading us into then, now we've covered the T's and C's and privacy policy, it all goes into sort of the 5 essential business documents I think every sort of coach, hypnotherapist, certainly service provider needs. Service agreements are also essential. It's really a contract outlining any scope of activities, timelines and responsibilities of both parties. So it really helps provide a clarity on deliverables and roles, and also helps define those boundaries. Now, a How I Work document is a business to consumer document which sets clear standards for things like communication and punctuality and mutual respect. Again, it builds on having terms and conditions where perhaps, you know, showing up late to appointments, you could have an appointment cutoff where they still have to pay, but if they don't show up, things like, you know, last minute cancellations. And the How I Work is also, you know, helps create sort of and keep the relationships really professional and really clean. And then, of course, a risk assessment. Andrea, if you're happy to run through risk assessments.
Yeah, of course. Basically, every business needs to have a risk assessment. And the idea of it is they've got to be legally compliant. So for it to be legally compliant, it has to be suitable and sufficient. And for that to be a case, they've got to clearly identify the hazards, the risks, and the control measures. They've also got to identify who's going to be harmed and how. So when it comes to things like risk assessments as a therapist, the hazards potentially, just off the top of my head, could be a client that comes to you with a mental health condition, a severe mental health condition like psychosis, schizophrenia, potentially even suicidal ideations. There is a high risk there that therapy might not help them and it could make their situation worse. So we've identified the hazard, we've identified the risk. As far as control measures are concerned, what you could have in place for that, for instance, is a discovery call or a pre-meeting intake form where you categorically ask these people, do you have any of these conditions? And you list those kind of situations as mentioned. Get them to declare whether or not they have any of those things. Don't take it on face value, but ultimately you now have an auditable document because they've filled it in to say they do or they don't have. If they're ticking to say they have it, I would strongly suggest you do not work with them unless they get medical clearance from a neurologist, a psychotherapist, a GP, somebody with a better qualification than we have and better knowledge than we have for this kind of thing. And obviously then part of your control measures are going to be that audit process and that selection criteria in those processing that basis. But obviously the idea of a risk assessment shows that you've carried out due diligence as part of your processes and procedures, and that you're very careful about who you choose to work with. Now, the beauty of having one of those intake forms or options where they tick to declare that they're fit to continue is that part of that onus then transfers from you to them. Because ultimately you need to be working with people aged 18 or over. They need to be legally compos mentis, as in of sound mind, to be able to fill that form in. And if at any point during your interaction with this person or these people, you think, hang on, there's something not quite right here, you have to be the authority in this conversation and you have to categorically decide what you do next. And there is no harm in saying, I'm sorry, I can't work with you. And that could be until you get clearance from a medical professional with a specialism in that field. The danger you have is to continue with working somebody who you suspect might be struggling with some mental ill health condition of a serious nature, because you don't know what damage it's going to do. You don't know what it might trigger, and the effects could be quite catastrophic. Not necessarily for you, but certainly for them and or their immediate family. So if in doubt, give it a swerve. Don't take it on. Now, the benefit of the risk assessment is you can have a generic one, which essentially carries out the majority of that work. Now, what you can do is you can then communicate that. You can put that on your website, or you can put that in your intake form by way of certain questions. But either way, it identifies and manages the risk, which will also help potentially with things like insurance. Because if your insurance needs to get involved for whatever reason, usually when something's gone wrong, this is where your audit trail is going to be crucial. And that audit trail is going to be things like the intake form, the booking system, the whole way that people book to work with you. Another side of that as well is, do you record your sessions? Do you record your discovery calls? Because if the poo hits the proverbial, how can you prove you did or didn't say or do what they claim you said or did? Because that's one thing to think of.
So I have a question there. Or
Okay.
So service agreement, how I work, and risk assessment. Do they have to be actual documents like PDFs, or can I just put them onto my website? I think you touched on that. But the service agreement, does that have to be auditable? Do I have to send them a PDF via email, for example? Are there any rules around that?
It's better if you have, again, this service agreement, the how I work, the risk assessment, privacy policy, T's and C's, it's all part of the audit trail. It all points to legal compliance. Now, the beauty with the service agreement is it's the nuts and bolts of what you're going to be doing for that one person. So that could be a case of you've agreed to a package of 6 sessions for weight loss. This is how it's going to be delivered. This is what you need to do. This is when we're going to do them. And it's basically the nuts and bolts of what they have to do and what you're having to do. So it is literally an agreement between the two of you so that you both know what's expected of each of you. It could also include things like, turn up, make sure you're ready to go at 2 o'clock if your appointment's 2 o'clock. Log on 5 minutes before. You've only got an hour. That kind of stuff. It details the scope of the services, the timelines, and like it says there, the responsibilities for both parties. The how I work bit and the risk assessment. The risk assessment, like I said, can be generic. And once you have it, there's no reason why you don't or you can't put it on your website. So then it's there for everybody to see, and a reference document. Make sure it's stated as a generic risk assessment if that's the case, because then what you will have to do is produce what we call a dynamic risk assessment based on, let's say, the intake form that you might have when somebody signs up to come and work with you, because you're risk assessing the answers that they're giving you as to whether or not they're a suitable candidate or a suitable client for you to work with, or like I said before, whether you need to give them a swerve or refer them back to a medical professional before you can continue. Did that answer the question, or did I miss something?
You did miss something, but that's fine.
Remind me.
No, the term document, does that mean I can put the generic risk assessment on my website like my terms and conditions? Or would I have to individually point it out to them by sending it to them or referring to it in some way?
Okay.
Yes,
yeah.
In which way?
Your generic risk assessment can go on the website, just like your terms and conditions. And it would be well advised to mention at the point of booking or on the website, subject to terms and conditions.
Subject to.
Okay.
Yeah, because a big part of it is communicating them to our clients and the clients. So if there's that block before booking, you have to agree to the terms and conditions, then it's extra protection and things like that. And if they don't read them, they don't read them. But by ticking that box, they've said they have and that they agree to them. So.
And same with the how I work, or would you always have for your different services, if you do have different services, make up a document to cover that?
So the how I work, I'd certainly do it with one-to-one and one-to-group sessions, and send it out as part of pre-session or pre-booking, so that again, it's the how I work is much more of like a standards and expectations in that sense. So the mutual respect of showing up on time, and it is all backed by terms and conditions sort of principles as well. So, you know, it's don't, like I said earlier, don't show up 15 minutes late and expect the session's still going to be there when I've got other clients and things like that.
Okay.
But yeah.
Thank you.
Can I just ask a question? So
Yeah,
would we be better to record our sessions just to keep us covered?
Yeah, I'd certainly recommend recording sessions. Obviously, that has to be disclosed as well upon booking. I don't think we've ever had any sort of reluctance to even, you know, participate just because it's recorded, thankfully. But it certainly keeps us definitely protected.
I never record anything because I don't want to keep, because that's like comes into the GDPR compliance as well. So it's catch-22 really.
Yeah. Yeah, it's a difficult one to navigate. I think it's better to be safe than sorry in a way, because like you say, if you have a client who turns out has sort of psychosis and has a negative effect from hypnotherapy but didn't disclose that, then perhaps, you know, your session can be recorded and you can go you know, if it needs to be brought up, then you can go exactly through that and what you use and things like that. I'm not a hypnotherapist, but maybe someone else jump in.
Yeah, what I will say is I record our discovery calls and I record our sessions, and I make sure that the people sign or they tick a box at the point of the intake form and the pre-session declaration, just to confirm that they're okay with it being recorded. And because we have tight GDPR, what do you call it? Oh heck, what do you call it? Procedures in place, I know the data is safe. So I'm not worried. And if you do GDPR properly, it's a helpful tool for your business. It's not something to be scared of at all. It's just you need technical and procedural ways in which to protect that data. And if it's just you running the business, it's a lot easier than if it's, say, a large company with 30, 40 different departments with maybe 100 people in each department. Because at least if it's you are both a data controller and a data processor. And as the data controller, you decide what information you want from those people and when, because you also know why you need that information. And there's absolutely no problem with you asking for that information if it's in the interests of health and safety. So to determine if somebody is psychotic or not is in the interests of health and safety, because you don't want to do harm to that person. And while we have GDPR, we've also got health and safety legislation. Now, health and safety legislation will ultimately have, I wouldn't say it's going to trump GDPR, but it's got a legitimate reason. If you've got a legitimate reason to be asking for the information, then it's not an issue at all. And like Alex was saying, I think I touched on it earlier, if it goes Pete Tong and they're claiming you must have implanted something into their head while you were under hypnosis or while they were under hypnosis, because you did not have any intention of robbing a bank, and yet suddenly you found yourself robbing a bank, it must have been what the hypnotherapist said to you. If you've got a recorded session, it's going to defend you. Unless you did actually tell them to rob a bank during hypnosis, which that's not going to help at all.
So I have
I
another.
will if I'm getting a bit of a take in it.
There you go. Oh, you're getting a take in the proceedings?
I have a question regarding that as well. So I can ask them that I will be recording it. How long am I allowed to keep it? Like if somebody comes back after 2 months and says something, or after a year, am I allowed to keep those sessions for a year?
Check with your insurance policy, but I think in some cases where it's health related, I think it can be kept for up to 7 years.
Oh, okay. All right.
Yeah.
And do I have to tell them if they have ticked a box, this session might be recorded? Do I have to actually tell them I'm going to start recording now?
Well, usually, like we had with Zoom, it
Yeah.
pops and it automatically tells you recording in progress.
Yeah, there may be people who use a screen recorder, for example. Would that be necessary to tell them again that it's going to be recorded?
If you're doing the recording, your software should do it, shouldn't it?
Yeah.
Yeah, I think naturally as well, you know, in sessions we sort of say, okay, you're ready to start. Start. I'll record now. Hit record now.
Yeah.
Yeah. If that's
Yeah,
what
but
you
if it
mean.
doesn't, I mean, I know people who use, for example, OBS to record, you know, Zooms, and you wouldn't be hearing an alarm.
Okay. Well, yeah, in that instance, it would be the better thing to do to let them know recording starts now.
Yeah, good practice. Just keep communication open.
Yeah.
And there's a good question coming in. What if they want their data removed and deleted? Imagine you've got somebody. Oh no, there's a case for you. So you've got somebody who accuses you of implanting the idea of robbing a bank in their head, and then they also at the same time want their data removed and deleted. How do we deal with that? I've had something similar to that.
Well, they will have to put a request in writing for that data to be erased.
Yeah.
Is there any time frame by which that has to be erased?
You've got, again, it's going to be right to process. You are entitled as a business owner to say you need something like 14 days or 21 working days to process any requests.
And
What I would do in that period of time is I would contact the ICO from the UK perspective and say, I've got a bit of a problem. You strongly suspect one of your clients has gone and robbed a bank and they're asking for their data to be erased. However, the data we hold will prove that we did not
do that.
want the
Yeah.
suggestion.
What is hilarious? Sorry.
No, it's fine. If you get the ICO involved, at least you've made the contact with the authority.
Okay.
Yeah.
If you just erase it, you're potentially on a sticky wicket at a later date, or it goes to court and it's their word against yours.
Right. Would I be allowed to take a transcript of that video data, or is that as well?
That's technically data. You could take the transcript and remove any references to the person.
Yeah. At which point you can store it pretty loosely, but otherwise, yeah, any identifiable sort of feature,
Yeah.
you'll have to have it on your processor. That's, you know, GDPR locked.
Okay.
Ready, secure. Yeah.
So in an anonymized fashion, that's possible. Okay. Wow.
Yeah. Yeah. If there's nothing identifiable, then get away with it. Yeah.
Great. Thank you.
Good question.
Okay. Yeah.
You know, obviously, this is something we do, or this is something I've been working with for a long time. And Alex, as he said earlier, came through with the intention of doing corporate law and contract law. So what we're trying to do is help people get ahead of this curve, because the last thing you want is the added stress and pressure of, I've had a claim, I've had somebody wanting a refund, I've had somebody claiming they've damaged me. And in the meantime, you've still got to function. You've still got to run the business. You're still going to have clients that you need to see. You're not going to be on your A game when that happens. You're going to be doubting yourself and your abilities. And then you're going to potentially have reputational damage from people that just love to gossip. Oh, did you hear about so-and-so? They've got an X, Y, and Z going on. So a lot of the stuff you can do up front by getting your documents in place, your terms and conditions, your privacy, the management and storage of data. Once that's all nailed, you can sleep easy.
Yeah.
And again, just by taking recordings of these sessions, it's something you can rely on. You might never need them, but you never know. Even if you just hold them for 12 months potentially, and then get rid of them. It's almost like that window of time has passed. If anything was going to bite you in the butt, it would do probably within that 12 months. But that's
exactly. Yeah. If you get these policies nailed, then I mean, really, the foundations for your day-to-day service are protected. I mean, you're doing such a great service with hypnotherapy and coaching for, like we said earlier, people who are really struggling, but they can also come in at small business owners is quite hard when they don't get their way or it doesn't go how they expected. So it's really just about protecting your, you know, putting you first in this case, which is absolutely, you know, you absolutely should be doing. Yeah.
And the other thing to bear in mind as well is when there is economic hard times, you will invariably get people who try it on. So somebody will book a session with you You'll treat them for something or other that they came with. And then before you know it, they're coming back to you to say, oh, you've caused me some damage. And then they'll try and put a claim in against you through your insurance. Because it's just human nature. When things get tough, the less desirables, shall we say, will come out of the woodwork and make things difficult. And they target businesses because they know you're insured. You'll see a lot of this with company vehicles on the road that are liveried up. There'll be there'll be an increase in things like rear end shunts, which are fake because the car in front slammed all on, made you run into the back of them. And if you're in a company vehicle that's liveried up, you're automatically at fault. And there was a big case of this in Wilmslow years ago, where there was a particular roundabout where it was happening a lot. And it just happened that on the same roundabout was an office block. And the office workers noticed, oh, another accident, another one. There's a lot. And it was when the police got involved, they actually found a gang in Manchester that were deliberately targeting work vehicles and causing accidents so they could claim whiplash and all sorts of other bits and pieces. And as therapists, we're not immune to those kind of people and those kind of claims. So again, by doing business on your terms and having the right protections in place, you're not only protecting your business, you're protecting your sanity and your livelihood. So that's the bigger picture. And it doesn't matter where you are in the world. If there's an economic downturn, people are going to be struggling. There's always going to be some business with insurance. Does that make sense?
Yep, it does.
Sad state of business, I'm afraid.
It's a bit sad, really, isn't
It's
it?
horrendous. It's horrendous.
I never even thought that anybody would even try that. It just did not cross my mind.
Yeah. And that's part of the reason why we do what we do when we do the legal packs. Because a lot of the stuff we do, we put together things like contracts of employment or terms and conditions of business for a range of different consulting companies. We do privacy policies for companies. And we do the things like we said before, the how I work and the service agreements. So we make sure everybody is as airtight as they possibly can be, even down to designing intake forms so that we know what questions to ask when they're booking a session with us or booking a discovery call, so that we can then filter out or get a feeling of, you know, I'm getting a sense of ick on this one. I think I'm going to give that one a miss. Because ultimately we've got the right to choose who we work with. And I would always say, trust your instincts. If you feel something's off, give it a swerve. Give it a swerve. How does that sound?
Yeah. Just sitting and thinking, yeah, that's good advice.
Oh, bless. Now, any other questions for us? Hopefully we not bored you to death.
No, it's
Yeah, a bit of a
very
dry
interesting.
topic. It can be.
No, it's been good.
Oh,
It's good to know, it's all good, things that we should know. Thank you.
Andrea, can I ask something? So the slide where you had the 5 different documents, initially when you started, I thought, oh, could you merge them so it's not then overwhelming for a client? But then I think by the end of what you were saying, I was thinking, no, you probably need to have these as separate documents so you can have them in different places or printed off, or because you don't want to make it overwhelming for a client.
no.
But it does need to be clear, doesn't it?
It does. The thing is, you can put your terms and conditions on your website and a little line somewhere that says, please refer to terms and conditions. And again, that can be on your website when they go to book an appointment with you, right underneath the button, subject to terms and conditions. And even if you put a hyperlink to your terms and conditions, they can click on it and read it. Hyperlinks are brilliant.
Yeah.
Now, once they've booked and they're having, let's say, a coaching package or something, or a package of, say, hypnotherapy sessions, that's when I'd send them a service agreement that just basically states, you've signed up for this, this is what you've paid, this is what you're going to get.
Oh, after payment.
Yeah.
Okay.
Hang on a minute. I'm thinking, no, when do we send ours? Yeah, we send ours out with the payment. So they book it. So it goes as part of the booking arrangement.
But they've already made the decision to book. The
Yeah.
service agreement isn't a part of their decision to book.
You would have had, what we would have done was, the way we do it is we have an intake form that goes out with a discovery call. Now, the discovery call is where we just get to know each other. What's your problem? Can we help you? Potentially, yes. This is what I propose we do. So your service agreement is almost like a proposal. It's this is what we've agreed to provide. This is what you're going to pay. This is how we're going to do it. You can even go to the nuts and bolts of this is when we're going to do your sessions. So they're pre-booked in. There's your price. If you're happy with that, sign and pay. And again, it's all subject to terms and conditions. Now, with that, we also send the how I work, which is the standards and expectations that pretty much says turn up on time or else you potentially forfeit your session.
Yeah.
And again, the discretion is on you as to how much of a window you want to give them grace, because a lot of it's going to depend on if you've got a back-to-back session with somebody else, because once you overrun with one, you know it's going to have a domino effect on the rest of your day. So unless you've got a decent window of breathing space and padding between each session, it could cause you problems. So that's going to be down to that service agreement or the how I work part. And then, like I say, the risk assessment can just go, the generic risk assessment can just go on your website as well. So the information's there. But like I said, your ability to communicate and transcend the risk assessment into real life comes onto your intake forms and the questionnaires that you ask, because that's part of your control measure. Then asking them, A, what's your age? And B, have you got any psychological issues we need to know about or any reason we shouldn't work with you? And I always put on the intake form, is there anything else we need to know?
Right.
As a catch-all.
Do people ever put anything in there?
No, a lot of them will answer, and I've made it a mandatory where they have to answer it. So you'll get people saying, no, I think I've got everything. Or no, I've answered everything. So then it just makes them think about anything else that they've not declared. Because then if they come back at you at a later date, oh, well, you never asked me.
Oh, yeah.
Oh, really? Yeah, okay. Well, I'm not going to ask you what your inside leg measurement is. But the onus is then shifted back on them. Is there anything we need to know? Bearing in mind, we've just asked you about psychosis. We've just asked you about medication. We've just asked you about depression and suicidal ideations. Anything else we need to know?
Right. Do you like, I mean, I can imagine that lots of people listening now or watching the replay, whichever, might have questions. Do I have everything in place? Do you offer anything like audits or whatever of websites? Because most therapists I know have just a standard website built for them, or just take like, Squarespace website or whatever and just put some pictures and text on there. Do you provide any services that would help them make that legally compliant?
I could if I was doing it under my risk and health and safety business. But what we were doing from an Nature's Way perspective, because it's purely therapy, hypnotherapy, and NLP, is we were actually offering a done for you pack, legal pack.
Right.
Which also included updates. So if the law changes, we would tell you by paragraph, that's changed. Here's an updated version, or just change that paragraph to this. And there'd be, and we were offering that to anybody potentially in your group at a discounted rate if they wanted it. We've got 3 potential packages.
Do you have anything on? Show
Let's have
us.
a quick look. There might be something on the back of the presentation. Just bear with us a second. All right, yeah, there we go.
All right, cool.
So we've got like a starter pack. That's essentially for anybody that's just qualified. Starting.
It's not on the screen yet.
Yeah,
you've got
that's the one.
Do you want to share screen?
Oh, sorry, I've not done it again. Oops. 1 second.
Looking into space.
Oh, that's right. What a beautiful space. Right, let me get that one. That one. Right, can you see the screen?
Nope.
Oh, again, hang on. Darren, Zoom, share. There we
There
go.
we go.
Nice.
Right, back up to the big one. There we go. Right, so yeah, you've got a starter pack. So that's essentially for somebody that's potentially just qualified or within the first 6 to 12 months of business, and they're treating clients, taking bookings, but they haven't got things in place, or worse, they've copied somebody else's terms and conditions from another website.
They've copied terms and conditions from other websites.
Yeah, I see that a lot.
Oh,
Yeah, and privacy policies too get copied.
Yeah.
When they're using different processors and data processors, so they're completely non-compliant.
Yeah.
Oh, so that means if you just copy and paste from elsewhere without actually paying attention to what you are doing, you are still liable and
Yeah,
in trouble.
Yeah.
massively.
Okay.
Yeah. So it's to be avoided at all costs.
Mm.
So when we did the starter pack, we did it to look at covering people that were doing one-to-one sessions or one-to-a group. And that would be either online or in person.
Mhm.
So it's literally time traded for expertise with the
Yeah.
people. So we included the top 5 essential documents as seen, but it's bespoke to that industry and that level of service that's being provided. We then ramped it up to the growth pack to include other things like digital products, memberships, and courses. Because again, there's going to be a different level of GDPR compliance required and a different level of extra protection as you broaden your services. So everything included in the starter pack, plus the policies for selling digital products and services, and then refund terms tailored to those digital products.
Right.
And then the last thing we did was throw a commercial pack together, which includes everything in the growth pack and the starter pack. And that's ideal for anybody who then wants to get into, let's say, presenting, or what is it, hypno thoughts or Irish hypno convention, that kind of stuff. Do we know anybody that's going there by any chance? But we're looking at business to business, ideally, or specifically in this one. So it looks at comprehensive protection, no matter how big your business gets. So you've got everything in the starter and growth pack, as I said. You've got B2B, so business to business agreements for corporate clients and events, including things like venue hire and partnership agreements. Because ultimately you need to know, if somebody pulls out of the event, who's picking up the bill?
Yeah.
Because there's a good chance the hotel would have been paid for, the venue would have been paid for. And if you are potentially one of the organisers, you could be liable for those costs, either in part or in full. And the difference that makes the difference is what's in the contract,
Right.
what's in the terms. And if there's nothing in there, good luck dodging that bullet.
Sounds like I need that one. Sorry, just laughing.
And again, there'd be a different risk assessment for that one.
Yeah. Okay, so how many arms and legs do I have to pay for the commercial pack? Get it?
How many have you got?
Yeah, you have to ask.
Yeah, you
I have to ask. Oh, okay.
Right.
Oh, that's not too bad.
Just for you guys. So these are normally retailing at 147, 247, and 397 respectively. So exclusive offer is 97. Is it 197? Because I've got a bar across the bottom, can't see. And then 297 for the last one. And then with that, you'll get your legal basis covered. So the essentials will be sorted. Obviously, you've got to sort your own insurance out. But then also you'll get updates. So when the law changes, we'll let you know and we'll tell you which section of each document needs changing.
Well, that sounds better than getting done for something.
Oh, yeah. And like I said, if it can just save you pulling your hair out and the added stress of help, please, they've paid the money for this thing and I've spent it and they want a refund. How the hell do I pay them back?
Yeah. All right.
What's in your terms?
Well, give me your links and stuff and I'll put them into the replay then. in case somebody wants that, because it seems like we do need to do something here.
Yeah.
God, did a good job at scaring me anyway. All right.
I'll stop sharing this then.
There's a link right at the top of the chat. Hopefully you
Top
can
of the
see it,
chat,
or I'll
right.
do another one just in case.
Oh, there we go. Yeah.
Yeah, is it
Let's
still in there?
put
Yeah.
that in at the bottom again.
And that's just
There we
for a discovery call, or, register, and then we'll chat and see what it is that's sort of best for you. So it's
So you don't
not
need
hard
to buy
No,
it.
no.
I'll let you
We
know.
want to make sure that you've got the right service pack.
Oh, would
Yeah.
that be even? Oh, yeah. Would that be
There's no
even?
point giving you a starter pack if you're then going to be doing digital products in 6 months' time.
Yeah.
Yeah.
No, but would that even be important for somebody like me? I'm in the Netherlands, and other people here in the US. So would that be?
Potentially, yes, because we can get you legally compliant, especially if you're dealing with data subjects in Europe.
Yeah.
Because that is going to
Totally,
apply no
yeah.
matter where you are in the world.
Mm.
A lot of the time with contract law, it's just an agreement that sets out the stall for what's happening there and then. Now, obviously, there's a hell of a lot of different legislation that goes into being and forming business law, contract law, company law, all that kind of jazz. Even Provision of Goods and Services Act and whatever else, there's a shed load. So by distilling all that information into these things like terms and conditions and policies, it takes the legwork out. The thing is, what we can do is we can put this thing together for you. And then if you just wanted to run it by us, we can check, because we've got access to legal databases and international databases, so we can see which laws apply. And then for Denmark or Amsterdam or anywhere else, we can sort of see, okay, yeah, you've got a domestic law that requires X, Y, and Z. And it could be something like digital products have a 14-day refund policy, which is going to be annoying for you as a business, because that means somebody can come in, buy your top of the range coaching program at £6,000, download it all in 14 days, and then throw a refund request in. Because by law they're entitled to.
Yeah.
Mm.
And is there, like, would there be a difference between sole trader and company? Like
Only
company,
if you've incorporated.
if I was incorporated as opposed to as being a sole trader.
Well, obviously affects your liability in that sense, because the limited company will sort of take that, But if you're a sole trader, then I think certainly in UK law they teach that it leaves your personal assets open to prosecution. So I'd always incorporate. But again, part of the jurisdiction you can choose in the terms and conditions. If you're operating under English law, then that'll apply too. But if certainly in the digital age where you're offering products and you have a website, I think definitely wherever you are in the world, sort of the terms and conditions and privacy policy is just essential.
Yeah, pretty much. And this is there are differences in the UK between Scotland, Wales, and England, correct?
Yeah, so it's England and Wales is the jurisdiction.
Oh, okay.
Yeah. And then I didn't do Scottish. Anyone in Scotland?
Yeah,
sounded
Mandy's in Scotland actually.
Yeah, I have on my terms and conditions under privacy that it's under Scottish law.
Yeah.
Right. Okay, wonderful.
But again, we've got access to the UK law, including Scotland and Northern Ireland. So if there are any variations, we can access it and see what they are. Because generally when they publish an act, even if it's Data Protection Act, there'll be exclusions and or there'll be
some sort of harmonization as well.
Yeah.
They work hard to really harmonize it across territories.
Yes, sometimes they'll say except Section 3 for Scotland or additional Section 8 for Northern Ireland. So each of the acts, and we go to the pure law, we don't go to guidance. So we read the actual statutes, and everything we do is built on what that is. So it's verbatim, then we just translate it into easy speak. Because ultimately, when you produce a set of terms and conditions, it doesn't have to be in legalese. And as long as it's easily communicated and understood, that again puts you in a better position as well if anything does go to court, because then you can clearly say you've communicated it.
Yeah, isn't there actually a rule that it has to be clear? Because I remember Facebook and lots of places made their terms easier to understand.
Yeah.
Yeah.
They've even dumbed down the law degree. So from when I did it, Latin played very heavily in the academics. And I know that by the time I was talking to law students, including Alex as well, I don't think there's been as much Latin as what we had when I did it first time round.
No.
Wow.
Yeah. It's got to be understood. It's like anything health and safety wise. It's all about the communication, and the message has to be understood, because if it's too complex and too difficult, they can wangle the way out of it, which is why, again, we say don't copy somebody else's terms and conditions, because if they've gotten very clever and copied some legalese rubbish and you don't understand it,
Yeah,
you can't defend it. You're going to struggle.
it's true. Any questions? Any random questions of any kind? You've got two experts here of anything. I think I had a question earlier. Wait a second. Oh, yes, that's right. I wanted to know if you've had a client and they come back to you saying that you've made them worse. Oh, you did cover that, didn't you? Yeah. So I don't have to wait a second. So once I've shown them my all my legal documents that you've shown us, I'm on the safe side. They can't do anything.
Basically, yeah. As long as they've ticked something to say they've seen it.
Yeah. Okay.
Yeah.
Even if they say it's made them worse, would there be a burden of proof at all? Do they even have a case of any kind? Or is it just like, well, gone?
Well, again, if you've got a disclaimer
Mm-hmm.
to say that everybody's different and results may vary, potentially not. Because again, if they've ticked everything, say, no, I don't have psychosis, no, I don't have X, Y, and Z. Again, providing you're working well and your suggestions are honest and clean and whatever, and you can prove it, you've got no claim.
Yeah. So always record, basically.
Audit trail.
Yeah. What if I don't record and somebody comes to me like that and they have signed the conditions and terms and conditions, everything?
Who are you talking about, Astrid?
I'm not myself, no. Just imagine you don't record sessions because you thought, like Mandy, because of GDPR, you don't. But you've got your terms and conditions in place, all the how I work, all the documents, and somebody comes back to you and claims you've done this, you've traumatized me, you've implanted the idea to rob a bank in my head, or whatever it is. Yeah. Does that concern me, or is it because they've ticked those boxes, I'm done as well? I do not have an audit trail.
You're partially covered because you've got a risk assessment that is going to identify the chances of a situation being made worse. So your due diligence is by asking those questions proactively. Is there anything likely to make your condition worse? And again, it might be worth asking, is anything likely to trigger you? Do you have any fears or phobias? So then before you get into the session, you don't then introduce, let's say we're going in a submarine and you're claustrophobic and you've got a fear of water.
Yeah.
So if you can navigate that before your session, again, you've done your due diligence. So then the chances of something adverse happening is off your shoulders, back on them.
Okay.
Now, there's no guarantee that somebody at a later date is not going to have an adverse effect, but that could be completely unknown to you and them.
Yeah.
At which point you're still going to have to get a second opinion to sort of say, well, prove it, because your insurance company is probably going to want to ask questions of them anyway. And in that instance, those questions would probably be handed to your insurance company to do the investigations.
Right.
And they might have to go off for medical tests and treatments and God knows whatever else.
Jesus. Okay.
But that's up to them. That's for the insurance company to sort out.
Yeah. All right.
Like I said, if you're proactively asking stuff up front and they either don't know, never happened before, or to the best of their knowledge is not a problem, and you've asked, and or you've tailored your sessions based on the information you've got, there's not much else you can do.
Yeah.
And because you've got the risk assessment, it means you've considered those options and you've put things in place to test it, if you like.
Mhm. Right. Okay.
Does that sound all
I
right?
have a question. Yeah, I have a question. So where do we store all these recordings safely?
Safely. I don't know what technology you've got at your side.
I've got a MacBook here.
A MacBook.
Okay.
You save it to the cloud or anything like that? Sorry, Mandy, you've muted.
Sorry. Yeah. I usually just save it onto my computer. I don't save it on the cloud.
All right. Is your computer password protected?
Yeah.
Okay, so that's
Yeah.
Yeah, and
So if
software
you're going to
up
be
date.
recording, if you're going to be doing all of these recordings, that's going to take up an awful lot of space. So would it be better to have it on an external drive, or I don't
Potentially.
really want to put it on the cloud?
Potentially. I store mine on an external drive and also on CDs, because I know from history clouds, the hard drives can get distorted, disrupted, and then you can't access the data anymore. And then I've got like a CD backup, just so that there's a hard copy in case I need that. But then again, after 12 months, they get shredded or deleted. You could technically delete them after
Okay.
6 months.
Thank you. Yeah.
Very, very safe.
Mhm.
Right. Okay, guys. Anybody got any more questions? Because otherwise I'll close the session. It's been 1.5 hours. Almost. Yeah.
Yikes.
Yeah. It's a long time. All right, then. Thank you to Alex and Andrea. And yeah, you'll be seeing the replay soon in the group, probably tomorrow sometime. I'm hoping. And yeah, just get in touch with Andrea and Alex. Oops, somebody left. If you need anything. All right. Thanks a lot. Bye-bye.
Thanks, everybody.
Thanks,
Thank
everyone.
you so much.
Thank you.